Your Honors, and may it please the Court, my name is Grant Bacon, and I represent the appellant in this case, Blanche Braun. I'd like to reserve 2 minutes at the end for rebuttal. The ability of an individual to publicly express their opinion is one of the most sacred rights protected by the First Amendment. Despite her status as a public employee, the appellant still enjoys broad protection under the First Amendment as long as her speech pertains to a matter of public concern and is made in her capacity as a private citizen. Once this has been established, the burden then shifts to the employer to show that her speech act somehow interrupted the operations of the organization for which she works. Your Honors, the appellant's action of liking a Facebook page dedicated to the Aryan motherhood falls squarely within these parameters. To begin with, I'm going to talk about the jurisdictional issue facing this court. Then I'm going to move on to the First Amendment issue, and finally conclude with the qualified immunity issue. Overall, the circuits are split on the issue of manufactured finality. When considering it, courts have considered the manner in which the plaintiff manufactured the finality and considered that to be important, looking specifically for manipulative intent, deception of the district judge, and so forth. Here, Braun sought to dismiss her remaining claims in order to appeal the important free speech claim, which was central to her case. Braun did this with full knowledge of the district court judge. His signature is on the order, and without any sign of manipulative intent.
So are you saying it's okay for a district judge to manipulate our jurisdiction?
No. Your Honor, the courts have specifically looked for the manipulative intent of the plaintiff when trying to decide if the manufactured finality actually did produce an appealable order. In Fletcher v. Gagosonian, I'm sorry, it's a difficult name, the Ninth Circuit held that the manipulative intent is what made the final appealable order not present. So the district court judge in that case had specifically denied an interlocutory appeal after an adverse judgment as to one of the claims. Afterwards, the plaintiff sought to, by stipulation of the parties, dismiss the remaining claims in order to secure what was an unavailable interlocutory appeal. Further, this court has interest in reviewing de novo the lower court's decision based on the new case law out of the Fourth Circuit under Bland v. Roberts. As a result, this court should find the appellant had properly dismissed the remaining claims, creating a final appealable order as to claim 1, meaning this court has jurisdiction to hear the appellant's case.
How is there a final appealable order when we still have these two unresolved and unaddressed claims kind of floating out in the ether?
Yes, Your Honor. Catlin versus the United States, which is a Supreme Court case from 1945, held that a final judgment for purposes of appeal happens when the district court ends all litigation on the merits and there is nothing left but to execute the judgment. Here, Braun received an adverse judgment, in this case, summary judgment, as to count 1. After the dismissal of counts 2 and 3, it created a final appealable order as to count 1.
That wasn't a dismissal with prejudice. It was a dismissal without prejudice, which means they can still be litigated. It seems like there's work remaining to be done.
Well, as I said, Your Honor, courts are split on this issue. Courts that have decided that dismissal with prejudice does create an appealable order as to the already adjudicated claim have done so because of the openness with which the plaintiff conducted the dismissal and because of the permission that was received from the district court judge, and that's the D.C. Circuit from 2009 in Robinson Reader versus American Council on Education. They held that the dismissal without prejudice was proper as long as they got the permission from the district court judge, which fits nicely in with the manipulative intent searched for by the Ninth Circuit in Fletcher. They're looking for the intent of the plaintiff in manipulating the judicial system.
Wouldn't it be easier for us to just go along with the majority of circuits, not concern ourselves with intent, so we don't have to look into intent at all and not allow these appeals?
Well, again, it's not the majority of courts. It's a split. The circuits are split on the issue.
But more don't allow it than do.
Well, Your Honor, this court should move on with the jurisdiction. This court should hold that the jurisdiction is present in this case because of the intent of the plaintiff. Further, judicial efficiency demands that an important claim, once it's been adjudicated, go on to be heard on appeal if it's an important claim. Now, the peripheral claims counts 1 and 2 were dismissed without prejudice, yes, but as stated before, this is the central important claim to the case, and as master of her case, Braun has an interest, and this court has an interest in hearing the case without going through the formality of litigating the two peripheral claims. Moving on to the First Amendment issue in this case. Relying on the lower court's decision in Bland, the district court in this case found that Braun's liking of a Facebook page did not meet the prima facie showing of a First Amendment violation of a public employee's rights. However, under the Fourth Circuit's analysis of Bland, it totally reversed the decision which was relied on by this lower court. Braun's actions fall squarely into the decision that the Fourth Circuit produced in Bland. Further, the district court didn't apply the balancing test found in Pickering. Under the Pickering test, an employee's free speech protection is still available as long as their comments address a matter of public concern and were done in their capacity as a private citizen. Once this has been established, the burden then moves from the employee to the employer to produce evidence showing that the employee somehow hindered the operations for which, the organization for which she works.
What's the employer's standard of proof there? Preponderance of the evidence?
Well, there's no specific language there's no specific language detailing the standard of proof that must be produced by the employer. However, in this case, the appellees have provided no proof. At the district court level, there wasn't even an argument as to the Pickering balancing test. As a result, summary judgment was improper for the appellees. Instead, should have been granted in favor of the then plaintiff, now appellant Braun.
So it was improper because the district court applied the wrong test? Is that your argument?
Well, the Pickering balancing test involves sort of a prima facie showing to begin with, and it incorporates some of the prima facie case language. And so when the court looked just to the prima facie case, they erred because they did not also look to the balancing test in Pickering. To satisfy the prima facie case of a First Amendment violation, a public employee must show that their speech was constitutionally protected, that they suffered a deprivation likely to deter free speech, and that their speech was a motivating factor in the employer's action. Here, Braun's like was the sole motivating factor in Radcliffe's decision to restrict her Facebook access. This was an action not only likely to deter free speech, but was intended to do so. Because of this, Braun is able to satisfy parts 1, 2, and 3 of the prima facie showing. Under the Pickering balancing test, the public employee maintains their First Amendment rights as long as their speech was made in their capacity as a private citizen and pertained to matters of public concern.
Counsel, will you concede that Braun didn't intend to communicate anything?
Well, Your Honor, Braun did intend to communicate something.
What?
Well, when Braun liked the Facebook page, she was showing her approval for the message, or at least what she understood at the point to be the message of the Aryan motherhood. She's quoted in her deposition as saying, "I liked what I saw at that point and wanted to learn more," hence the bookmarking. And once she did like it, she went on to find out more about the Aryan motherhood and liked what she saw. In fact, after learning that it was not just a daycare organization, but was also a social group with social events and support groups for mothers, she called their activities, quote, great. So Braun did like the Facebook page to come back and look at it, but she liked enough so that she knew she wanted to come back and look at it. And when she did, she realized that she was actually very impressed with the Aryan motherhood showing.
So she accidentally communicated early and then found out later on that she meant that communication? Is that your argument?
Not at all, Your Honor. Braun knew that she liked what she saw, and so she liked the page. So I guess you could say it was a dual purpose like. It was to bookmark the page, but it was also an indication of her approval of what she had already seen. So just say that it was a bookmark only tells half the story, because there was also half of the story where Braun appreciates what she saw initially in her cursory look at the Aryan motherhood's Facebook page.
What was the public interest matter that she did like initially?
Well, Your Honor, the public interest matter, the Aryan motherhood is inherently the sole uniting factor behind everyone in the Aryan motherhood is racial segregation and racial discrimination. Courts have held that there are some there are some issues that are so inherently of public concern that they are considered matters of public concern in any context. Connick v. Myers, which is a Supreme Court case from 1983, on footnote 8, says that racial segregation is always a matter of public concern. So here we have a situation where public discrimination is always going to be a matter of public concern. And Braun saw the Facebook page dedicated to the Aryan motherhood and liked what she saw, so she liked the Facebook page so she could read more about it, but also to show her approval for what she knew at the time.
My concern is that she did not know that it was a racist group when she initially liked it, which is the speech in question. How does that make it free speech and on a public concern when she didn't even know that it was on a racial matter?
Well, Your Honor, Braun said in her deposition that part of her criteria for looking for a daycare was to not have her baby be the only white baby in the daycare. She was also specifically, because of the socioeconomic circumstances surrounding her search for daycare, it's clear that she knew that there was a possibility, especially in Deer Heart, where she might run into a situation that she was describing and was looking to avoid that. And so when she found the Aryan motherhood, it was clear she liked what she saw based on the cursory look, understanding that her baby, quote, wouldn't be the only white baby in the daycare. In conclusion, finally, moving on to qualified immunity.